Because of this, the Mexican cartel members get their guns from straw purchasers, people who buy guns illegally in the US and then smuggle them to Mexico to resell them. How the case got to the Supreme Court. In 2021, Mexico sued petitioners, a group of gun manufacturers, alleging a variety of claims related to the illegal gun trafficking. Before the trial could even begin, the court dismissed this case, holding that a law called the PLCAA barred Mexico's claims. However, in the United States First Circuit Court of Appeals, they overruled the district court and ordered the trial to take place. And secondly, the questions presented. Should Mexico's lawsuit against Smith & Wesson and other U.S. gun makers be dismissed because it's barred by the PLCAA, or should Mexico be given a chance to prove their case at trial?
Third, the law. In 2005, Congress passed the PLCAA, which prohibits lawsuits that seek to hold gun manufacturers responsible for damage done by their guns. Specifically, the PLCAA bars any claim against a manufacturer or seller of firearms for damages resulting from the criminal or unlawful misuse of a firearm by any third party. The predicate exception. However, there is an exception to this law, the predicate exception. The predicate exception states that the gun manufacturer can still be sued when it has knowingly violated a state or federal statute applicable to the sale or marketing of firearms. 4. Legal arguments. Mexico claims its lawsuit fits into the exception because the gun makers have illegally aided and abetted the dealers who have illegally sold the guns to straw purchasers, and those illegal sales are the proximate cause of the damage suffered by Mexico. Some terms to know. Aiding and abetting. Aiding and abetting means to knowingly participate in others' wrongdoings, and proximate cause exists when there is a direct correlation between the defendant's actions and the damage caused. Cases to know. Twitter v. Tandem. Twitter ran a social media platform and ISIS recruited members on it. Juanani Gonzalez was later killed by an ISIS attack, and her family sued Twitter for aiding and abetting ISIS. But the court dismissed the case because there was no evidence that Twitter had any knowledge about the specific attack of Gonzalez. Direct sales through the United States. Direct sales manufactured morphine and then sold it to a doctor who had illegally sold it to drug dealers and addicts. Direct sales was found guilty of aiding and abetting, as it was known that the doctor had been selling drugs illegally, and direct sales kept providing him with the drug anyways. Arguments you will hear. For the petitioners, Addie Whitfield will argue that the petitioners have not aided and abetted unlawful firearm sales, and for Mexico, Ann Crouch will be arguing that petitioners have aided and abetted and aided unlawful sales. For the petitioners, Alex Nelson will be arguing actions are not the proximate cause of Mexico's injuries, and for Mexico, Caleb Breach will be arguing that the petitioners' actions are the proximate cause of Mexico's injuries.
All of this information will be found in the pamphlet that you have received at the door. Thank you.
Now it's time to get to the arguments. The lawyers will argue their side of the case in front of the 9 justices who attended each. The justices will interrupt the students with questions about the case, and the students are expected to answer all of them in the time provided.
First, Addie Whitfield. They will be arguing on behalf of petitioner Smith & Wesson et al.
Second, Ann Crouch and Caleb Reeves. They will argue on behalf of respondent Mexico.
Third, Bella Moreland. She will argue as an amicus on behalf of Mexico against gun violence.
Fourth, Sahara Sullivan. She will argue as amicus on behalf of the National Rifle Association.
After all of the student lawyers have finished their arguments, the justices will then hold a short conference and vote on the cases. And then, over the next few weeks, they will write an opinion announcing, explaining their decision.
During this time, students will not know who won. They must wait until the opinion is released. The 9 justices in this case are
Chief Justice the Honorable Pamela E. Hutchins is a former judge of the Virginia Beach General District Court and is now an adjunct professor at the Marshall Witt School of Law at the College of William and Mary. She is also the parent of Cape Henry graduates Alexander and Caroline.
Alex Feisel is a Cape Henry graduate and argued the case of Bernard v. Minnesota to the Cape Henry Supreme Court in 2016. She is now developing a legal database for the Oxford University Press.
Gabrielle Cabreros is a Cape Henry graduate, teaches English in the upper school, and is the parent of Cape Henry students Margot and Keith.
Dr. Christopher Gehring currently serves as Cape Henry's 11th head school and president. He is also the parent of Cape Henry student Christopher.
Leigh Gregory, Esquire, teaches chemistry in the Cape Henry Upper School and is also an attorney specializing in patent law. She is also the parent of Cape Henry student Lee.
Kevin Keller, Esquire, practices law at Wilcox and Savage, PC. He is also the parent of Cape Henry graduate Olivia and Cape Henry student Grayson.
Julius Pleva is a Cape Henry senior and was voted best lawyer in last year's program, representing the city of Grants Pass in Government Grants Pass v. Johnson. He plans to attend North Carolina State University next year.
Kevin Sharp, Esquire, practices law at Shapiro, Washburn, and Sharp, PC. His wife Kathleen teaches English in the upper school, and he is the parent of Cape Henry graduates Colin and Nolan and Cape Henry student Kelly.
Will Trager is the head of Cape Henry Upper School, and he's also the parent of Cape Henry students Owen, Ella, and Lucy.
And now, please rise as Lila Shoemaker sings the national anthem.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rocket's red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say, does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Before we start, one special word of thanks to Chris Salver and the CHC TV Club for broadcasting and everyone out there watching on YouTube. That's it.
All rise. The Honorable, the Chief Justice, and the Associate Justices of the Cape Henry Supreme Court, oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of Cape Henry, are admonished to draw near and give their attention, for the court is now sitting. God save Cape Henry and this honorable court.
Councilors, we're ready to call the matter of Smith & Wesson versus Mexico. All parties ready to proceed? Thank you. Go right ahead, Councilman.
Madam Chief Justice, may it please the court, my name is Addie Winfield and I am representing the petitioners. Petitioners respectfully request this court to overturn the decision of the U.S. Court of Appeals for the First Circuit. In 2005, Congress passed the PLCAA Act, otherwise known as PLACA, to protect gun makers from being sued for damages caused by criminals who use their guns to commit crimes. Yet this is exactly what Mexico is trying to do in this case. It nevertheless faults petitioners for staying the course because in its views, they should have taken extra legal steps to better curtail the small fraction of U.S. firearms that end up in Mexico. This court should dismiss this case before trial because even if Mexico proves every one of their allegations, all they will have proven is that the petitioners operate a lawful business. Specifically, the court should dismiss this case for these 3 reasons. Number 1, running a lawful business cannot possibly be the basis of an aiding and abetting claim. If so, thousands of businesses and industries could be held liable for the misuse of their products by others. Number 2, this case is no different from the Twitter case, in which the court held that there was no aiding and abetting. And number 3, this case is completely different from the direct sales case, which Mexico's argument relies on. More on point 1. How running a lawful business cannot possibly be the basis of an aiding and abetting claim. These companies currently are doing nothing more than following the federal restrictions required to run a legal business, and Mexico wants them to take extra precautions in order to stop the violence in their country. Mexico is blaming Smith & Wesson for their lack of action towards a stop in their selling process, which they have been using for decades. The petitioners are not doing anything illegal by continuing their long-standing process that is approved and monitored by the federal government. Therefore, the petitioners could not be held an accomplice in any activities taking place after they have sold their products. Under Mexico's argument, each company would need to be held liable for the crimes committed by their products, which doesn't make sense for any industry. You wouldn't blame a beer or wine company for drunk driving or underage drinking. The decisions made by the customer are out of control of the company. If we were to follow through with this claim, the effect would reach farther than just the arms industry. The impact would be felt from alcohol to cars to knives. It would open up a doorway for many more lawsuits made by criminals. And the idea that these companies are completely aware of the harm caused by their products and are simply ignoring the repercussions, this is false. And even if it were true, the company being aware of the crimes committed with their products isn't sufficient evidence to be held against the aiding and abetting claim. Continuing on to point 2. This case is no different from the Twitter case, in which the court held that there was no aiding and abetting. A family of a man killed during an ISIS attack sued Twitter under the accusation that they were aiding and abetting the terrorist group. Well, in reality, there was no evidence to support that ISIS had used the platform to collect people, but simply was just using the platform. The court ruled in favor of Twitter because Twitter had made no extra steps or changes in in order to attract or help ISIS. This is incredibly similar, if not the same thing, Mexico is arguing here. The petitioners have done no illegal activity and have not been aiding and abetting the cartels because just like in Twitter, they didn't change the way they were acting. In Twitter, the court clearly establishes the overarching theme that companies cannot be held liable.
Excuse me. In the Twitter case, there was action taken to ban such ISIS accounts. But I have not heard of any action taken by the gun manufacturers to sort of ban dealers that have cartel connections. So could you please expand on that part?
So in the Twitter case, they were given notice of the ISIS groups and the use of their platform, as well as they had the products to and the ability to take down the accounts, but they did not act further on that, other than having been known that they were using their platform. Which, continuing on with the point.
Are there any safeguards being taken by Smith & Wesson to make sure that sales don't end up in criminal cartels' hands in Mexico?
Not necessarily, but their process has been legally stated in PLACA and is monitored by the federal government to make sure none of illegal things happen with the company.
So there's no allegations that they're violating any regulations or U.S. laws
Exactly.
for sale of firearms, right?
Mm-hmm. In Twitter, the companies must be proven to have interacted with the aggressor, which the petitioners never did. Petitioners simply followed their legal requirements as I stated above. Twitter clearly states that Smith & Wesson would have needed to specifically get involved with the cartels to make Mexico's claim correct. Mexico also needs to name a specific crime or group Smith & Wesson is aiding, which their argument now is simply too broad as it references to all the cartel violence in their country. Now for my third point, the direct sales case. The argument of the direct sales case is the exact opposite of the Twitter case is false, and they both truly prove the same point. A company cannot be involved in a crime without the direct involvement with the issue. A company cannot be in direct sales. A distributor is selling large amounts of morphine to a specific doctor. Now, the average amount a doctor gets is about 400 pills per year, and a specific doctor was being sold 79,000 in just 6 months. The distributor in this case increased the sales to this specific doctor over a long period of time in attempts to not raise suspicion. This clearly is different from the case we are arguing today, because Smith & Wesson have spent decades performing the legal selling tactics that Mexico is arguing against now. This clearly shows how the direct sales case shows no more than without direct involvement, Smith & Wesson should not be prosecuted for the crimes being held against them. In this case, like Twitter, rules that the company needs more than just the knowledge of the crimes being committed to be charged for the aiding and abetting allegations. The direct sales case also doesn't relate to this case since the distributor was going out of his way to hide what he was doing from the police, like how he changed the pill sizes and the direct sale to the drug dealer. His continuation and
Isn't the fact that more than half of the guns recovered at all Mexican crime scenes contain or are proven to be sold by American gun manufacturers more than just knowledge of the crime? Wouldn't that constitute more than just knowing that the crime happened, but knowing that there is some culpability on the part of gun manufacturers?
So more than 50% of firearms from the U.S. are making their way into Mexico, but there are guns coming from other companies as well. There's about 200,000 guns, U.S. guns going into Mexico each year, which is less than 2% of all the guns the U.S. is manufacturing. So because it's such a small portion of the U.S. guns, it's not sufficient evidence to be held against the gun companies.
Council, would your position change if instead of 2% it was 5% or 20%?
Perhaps, but that doesn't really pertain to this specific case.
I understand that, but I'd like to know from the reasons, if it were a greater amount, would that affect your position in your argument?
It would be possibly more closely related, but since it's so far out now, it's down the line, possibly, but not currently.
Are the current numbers not enough to reasonably foresee the crimes that are being committed in Mexico?
So the gun companies don't need to take the extra precautions needed, and even if the numbers were larger, it's not illegal for the companies to be selling to the wholesalers they're selling to now, who then sell to distributors, who then sell to the straw purchasers. So from where the gun companies are, they're not illegally selling anything.
So people's lives are at stake here with this case, and I just wanted to ask your opinion on, there's only 2% of guns being sold, but that's still causing a lot of damage in other places as a result of American gun manufacturers. So I would just like your thoughts on, even though it's only 2%, how are you gonna just keep holding them liable?
So the gun companies cannot be held liable for the deaths in Mexico because they're not legally selling their guns now. Nothing they're doing in the U.S. is breaking any laws, and all the crimes being committed are much further down the line and are out of contact with the specific manufacturers.
If there are only a few dealers who are selling to straw purchasers who are then exporting the weapons to Mexico, is your client aware of the higher volume to those dealers? And if not, or would it make a difference, you think, if they were aware that those particular dealerships, those particular gun dealers, maybe through wholesalers or I don't know, directly from the company, are purchasing more guns from your client and therefore passing them on to Mexico than would be expected for where those dealers are located?
So it would make sense if the gun companies were selling large amounts or an unusual amount to the specific wholesalers to sell to the straw purchasers. But in this case, the gun companies have not changed the way they are distributing their guns, so they have not added more guns for specific wholesalers or dealers who are breaking the law or selling to the cartels.
What do you think would qualify as an unusual amount?
So a number of guns given to each company are, may I briefly answer your question? I'm out of time.
Go ahead.
For the gun companies to, like an unreasonable number would be a much larger increase, like in the direct sales case when the 400 pills was changed to the 79,000. Thank you for your time.
Thank you, Counselor. When you're ready.
Madam Chief Justice, may it please the court, my name is Anne Crouch and I am representing the respondent Mexico. The respondent respectfully requests this court to affirm the decision of the United States Court of Appeals for the First Circuit. To begin, at this stage of the proceedings, the court must accept the following facts as true. Tens of thousands of Mexicans have died at the hand of cartel gun violence, killing 450 members of the Mexican Federal Police and National Guard, and 45 members of the Mexican military. This violence and damage has cost the Mexican government billions of dollars, and despite Mexico having strict gun regulations, hundreds of thousands of firearms make it across Mexico's border, and the majority of them come from the United States. Almost half the firearms that are recovered at these crime scenes of cartel violence originate from the petitioners being tried in this court. All Mexico is asking for from this court is a chance to present these facts to a jury at trial. Siding with Mexico in this case will not result in an immediate judgment against the gun makers. Rather, it would simply give Mexico a chance to prove its case at the trial. A trial that Mexico might win or lose depending on the evidence presented and the opinion of the jury. To be clear, all Mexico is asking for at this point is a chance to prove its case. The lower court gave Mexico that opportunity, and this court confirmed that decision for the following reasons. First, the petitioners have aided and abetted in the illegal sale of firearms in the same way that the morphine manufacturer did in the direct sales case, providing both knowing and substantial assistance to the unlawful sale.
Counselor, I appreciate that you're asking just to hear the case, but wouldn't you agree that if we allow the lawsuit to proceed forward, would it not open the door for other claims against other industries? For example, Mexico, which is one of the largest car manufacturing partners with the United States, be ultimately responsible if there was a drunk driving accident in the United States?
I understand what you're saying. However, the nature of the product being firearms, similar to narcotics as seen in the direct sales case, firearms and narcotics are held to a different standard as they are a different class of products, and therefore the manufacturers of these products must be held to a higher standard as well, and must...
Is that your opinion, or is that rooted in law somewhere?
The fact that this case is all about the statute that is designed to protect the petitioners make a difference to your answer?
To be clear, you're asking whether PLACA defines whether this case would apply to other industries? Yes, so the reason that the respondent should receive a trial as decided by the First Circuit is because it applies to the PLACA predicate exception, where it states that the manufacturer must provide aiding and abetting and proximate cause to the unlawful sale of firearms or marketing. Because of this, the case does not exactly pertain to other industries, such as the car manufacturers, as you mentioned, but it does pertain to this case where firearms are involved. Secondly,
if you were given the chance to, go to trial and prove your case, how would you prove, what evidence would you have that petitioners knowingly sell to straw purchasers, which would have to be true if it's aiding and abetting?
given the volume of the firearms that make it into Mexico, and given the reports from both the ATF, which is the Bureau of Alcohol, Tobacco, Firearms, and Explosives, given the notice from public media sources and the ATF, it is clear where the straw purchasers are located and where the illegal sales are happening. And and given this information that is available to the manufacturers, there is knowing assistance towards the dealers. The second point.
Counsel, one of the concerns I have about this, and maybe you can explain your position on it, is that unlike Twitter and direct sales where we knew who the bad actor was, this is sort of a global, it's just bad dealers and people that are, so it's not a specific group or a specific people. Can you talk about that a little bit, please?
Yes, of course. So, to be clear, your question is why are the manufacturers being held liable rather than the dealers?
Well, no. My question is specifically in Twitter, we knew that the ISIS members were the bad actors. In direct sales, we knew that the doctor who was selling the morphine specifically was the bad actor. Here, there are no named bad actors in the complaint. It specifically talks about straw purchasers, but who are these people?
Yes, so the straw purchasers, a straw purchaser is somebody who will buy a product on behalf of somebody who would otherwise not be allowed to legally purchase the product. And so the dealers are able to identify these straw purchasers through their reluctance to provide information or falsifying information, and the manufacturers are being held liable for the dealers.
Has the complaint named any straw purchasers?
It has not directly named any straw purchasers, but it has directly named dealers that are known to sell firearms in high volume to straw purchasers and other bad actors, such as purchasers who try to use high-pressure sales methods in order to increase the quantity of firearms that they are able to smuggle across the Mexico's border.
If they're smuggling across the border, isn't it technically the U.S. government's responsibility to make sure, like, what's going across the border, not a private manufacturer's? Or can you just expand upon that?
I would agree, and the respondent would agree that some protections should be made from the government to increase border security for all matters. However, that is not what is being argued in this case. The specific argument of this case is that the manufacturers are aiding and abetting in the unlawful sale of firearms, and so in order to mitigate the volume of these firearms getting to cartels, getting into the hands of cartels and causing mass mayhem, it's important that Mexico go after the root cause. It is suing dealers that are known to provide a large quantity of firearms to bad actors. However, even if it were able to...
Excuse me, I'm curious, you could just answer this. So we're talking about the manufacturers, these private manufacturers, but what about, is there any role for us, just to follow here on, like, I'll call it back on our ATF or other government entities?
Yes, so you're asking what notices do the manufacturers have?
No, I'm saying that in this case, obviously, you're trying to hold private manufacturers responsible. What I'm saying is there any role you see for ATF or other government entities? Do they hold any liability or responsibility?
Well, the ATF and other government agencies such as the Department of Justice are doing their part of reviewing dealers specifically and trying to review whether they should maintain their licenses or not. However, the resources given to these departments is very little, and so because of this, the ATF is only able to review about 3 to 10% of dealers within the U.S. in a given year. And so,
You selected as your primary and presumably most effective point of defining and arguing aiding and abetting, when in reality, the entirety of this case is not about the statutory language passed by Congress through the act in question, and the phraseology of aiding and abetting appears nowhere in the statute. Nowhere. The proximate cause does appear, but what is your intended reliance on the criminal interpretation, mens rea, pursuant to an aiding and abetting allegation, as it's applicable to this particular statute?
yes. Well, FACA states that FACA permits suits against gun manufacturers if the manufacturer, 1, knowingly violated a state or federal statute applicable to the sale or marketing of firearms, and 2, that the legal violation was the proximate cause of the alleged injury. To your point, we are arguing for the proximate cause, which is why it applies to FACA, but additionally, the aiding and abetting allegation is what connects the manufacturers to be knowingly violating a state or federal statute applicable to the sale or marketing of firearms. This
Yes,
is
we have no parties that identify with any degree of specificity in pleadings who were aided or abetted. No straw purchasers have been identified. Is that going to be a bit of a discovery fishing expedition to identify those ultimately if you succeed in this tribunal?
Yes, well, the petitioners being tried in this court are not being tried because of their direct relation to straw purchasers, but rather their engagement with dealers who are known to engage with straw purchasers.
But for the straw purchasers, we wouldn't be here today, correct?
That is true. Because of straw purchasers and high pressure sales methods, the firearms are able to make it to Mexico. However, the dealers are providing these guns to the straw purchasers, and they have ways of determining who is a straw purchaser. And the manufacturers get to choose who their dealers are because they're allowed to provide or not provide their firearms to whoever they choose. And so because of this, the manufacturers hold liability for their products.
Thank you, Counselor, and your time has expired. Thank you. Counselor, when you're ready.
Madam Chief Justice, may it please the Court. My name is Sahara Rose Sullivan, and I represent the Amicus National Rifle Association in support of the petitioners. The NRA is a powerful American organization which advocates for protecting our Second Amendment rights. The NRA was founded in 1871 by Union generals who sought to promote firearm expertise. Nowadays, the NRA holds true to our mission statement: to protect and defend the Constitution of the United States via protecting our right to keep and bear arms. The case Smith & Wesson Brands Inc. versus Mexico is an attempt to infringe upon American rights to keep and bear arms, therefore going against all that our organization has worked tirelessly towards. Mexico, in this suit, is attempting to impose their own laws on the citizens and the corporations of America. Mexico's Constitution of 1857 grants the citizens of Mexico the right to possess and carry arms for his safety and legitimate defense. However, in Mexico, there is but a single gun store. So, despite the right to bear arms existing in Mexico, the Mexican government makes it almost impossible to actually own a gun. Ironic, right? Now, the Mexican government is striving to implement its thinking on us. Mexico's attempt to impose its laws on United States corporations is a direct challenge to the principle of American sovereignty enshrined in our Constitution. By trying to hold American manufacturers liable for actions beyond their control, Mexico seeks to diminish the Second Amendment right of American citizens, which tears apart the Constitution's protection of the right to bear arms. Quite frankly, as an organization, the NRA is shocked that Mexico climbed so far up in the American court system because of the Protection of Lawful Commerce in Arms Act, enacted in 2005 by Congress, which states that firearm manufacturers and dealers are, except in limited situations, protected from being held liable when crimes are committed with their products. The court, allowing such a case, ignores Congress's intent in passing the PLCAA and is an infringement upon congressional power. Ignoring this act would be an uncalled for shift of power from Congress to the court, whereas legislative power does not lie. This suit should not be allowed under the PLCAA because making gun policy is beyond the court's jurisdiction. Mexico arguing for the gun makers to be liable for the acts of Mexican criminals contradicts the clear and unambiguous language of the PLCAA's preclusion of liability. This case is exactly why the PLCAA was enacted in the first place. The PLCAA is an expression of Congress's authority to regulate interstate commerce under the Constitution and to ensure that the Second Amendment right to bear arms is not undermined through lawsuits. By challenging this act, Mexico not only disregards the clear legislative intent by Congress, but also threatens the Constitution. This case sets a dangerous precedent that could expose United States companies to vulnerabilities. If foreign governments are permitted to sue American gun manufacturers for the actions of criminals in their own countries, it opens the door for other nations to bring similar lawsuits based on their own domestic issues. Such a scenario could have far-reaching consequences. United States companies could become targets for international legal attacks even when they are in full compliance with United States law. This would create a hostile environment for American businesses within a national market, ultimately undermining the protections that are essential to a free market. Allowing foreign governments to hold United States manufacturers accountable for criminal activity that occurs outside of their jurisdiction would weaken our laws and expose American companies to liabilities that have no basis in law or international legal standards. Further, Mexico, not the gun makers, is the party responsible for violence committed in Mexico. For example, Mexico complains that their homicide rates have increased due to assault weapons. However, their homicide rates were greater during the American assault weapon ban. Mexico's homicide rates also increased when President Calderon deployed 30,000 soldiers to battle cartels. What occurred was similar to war, with turf wars, military confrontations, and shootouts beginning. This exemplifies their government's own failure to protect their citizens and to prosecute violent criminals through their own legal system. The Mexican government strives to hold anyone but themselves accountable. Mexico is dealing with long-standing violence in their own country by pointing fingers, when really their hands should turn to point at themselves. Mexico's failure to address its own issues of violence internally while attempting to shift blame on the United States manufacturers once again violates our Constitution, which protects Americans' rights to defend themselves. The Second Amendment safeguards this right, and allowing this case to proceed sends a dangerous message that foreign entities can dictate United States policy on firearm regulation. Rather than spending money legally attacking American gun makers, they work on their own border security, ensuring that American guns cannot flood through their borders and into the hands of the cartel. By increasing surveillance and enhancing cooperation with the United States authorities, Mexico could stop the flow of weapons into the hands of criminals. Tackling the root of the problem at the border would be more effective than attempting to disrupt American sovereignty as a whole. In closing, Mexico's attempt to shift blame to American gun manufacturers wildly undermines United States sovereignty and infringes upon our Constitution and the Second Amendment. The focus of Mexico should be instead on addressing the root cause of their evils, illegal firearm trafficking, through whatever means they can. This case threatens not only the Second Amendment, but also the broader framework of our constitutional protections. Allowing foreign governments to override United States legal principles and hold American businesses accountable for their lawful acts erodes the Constitution. Upholding the Second Amendment and the PLCAA is essential to preserving free market integrity within America. Mexico's problems are sad, and they do need to be addressed. But suing the gun companies is not a just way for Mexico to fix those problems. Therefore, I respectfully urge the court to overturn the ruling of the First Circuit Court of Appeals and dismiss this lawsuit.
Thank you. Councilor Ringradi.
Madam Chief Justice, may it please the court, my name is Alex Nelson, and I am representing the petitioners. Petitioners respectfully request this court to overturn the decision of the U.S. Court of Appeals for the First Circuit. Congress passed the BLAC Act to stop lawsuits exactly like this one. Lawsuits that try to hold gun manufacturers liable for crimes committed with their guns by a third party. Nevertheless, Mexico is trying to get this court to do exactly that. Even if this court accepts that Mexico's allegations sufficiently allege aiding and abetting, which my co-counsel Ms. Winfield showed they do not, Mexico's lawsuit should still be dismissed, because even under their own allegations, there are 8 degrees of separation between the petitioners and the cartel's damages, or damages caused by the cartels. These 8 steps start at the licensed manufacturer creating the gun. The second step is the sale to a licensed wholesaler. The third step is a sale to the licensed retailers. The fourth step being a small percentage of those retailers selling to straw purchasers. The fifth step is the sale to smugglers. The
The sixth step is the smuggling across the board. The seventh step is the sale to the cartels in Mexico. And the eighth step is the cartels using these weapons to commit murder and mayhem in Mexico. Holding a trial in this case would be a waste of time and money, because the allegation connection between the alleged connection between the American gun makers and the Mexican cartels.
Excuse me, you said that holding this trial would be a waste of time and money, but wouldn't you want this type of case to set a precedent for all other future cases regarding the Blackwood kind of cemented in law? And just what are your thoughts on that?
I agree that there is an issue that needs to be solved, but this specific case wouldn't solve any of those issues given the manufacturers are not the ones that are in any way responsible for the damages happening in Mexico. So there should be time and money spent on solving the issue, but this case is not where that time and money should be spent to solve that issue. Mexico's complaint fails on proximate cause for two significant reasons. The first reason is that the chain of causation is too attenuated. As it was held by Holmes v. Securities Investor Protection Corp., the general tendency of the law is not to stretch proximate cause past the first step. Other cases have been rejected at 6 steps, 4 steps, and even 2 steps away from the damages. This case has 8 steps separating the petitioners and the damages. It would be unreasonable to hold that an 8-step chain would attach any amount of liability to the manufacturers for the damages in Mexico.
Excuse me, Counselor, how many steps would be acceptable?
I don't think the first step would be acceptable if there was a very clear, direct link on the first step between the manufacturers and the cartels and any illegal act being committed.
Is the name of the manufacturers on the guns found in Mexico crime scenes not enough of a proof?
The name of the manufacturers being on the guns does not create a link between their actions and the damages in Mexico. Their weapons are being misused by a third party. It is not their intent, nor have they taken any actions to facilitate these illegal acts. Thus, just because their weapons are being misused and sold in illegal ways and smuggled does not mean that there's a direct correlation between the actions that the manufacturers do legal against.
So just to follow again, so Smith & Wesson, short of Smith & Wesson putting the gun in the cartel's hands, is there any other scenario you can see that would lead to proximate cause?
Scenario that might lead to proximate cause could be a case like the Brady v. Walmart case. This is a case where the predicate exemption did actually take place and there was a seen proximate cause. In the Brady v. Walmart case, Walmart sold a gun to a visually impaired man and they were sued for the negligent entrustment of that weapon to the visually impaired man. Now, that case is different than this case because, one, Walmart was the direct dealer of that weapon. They committed a very clear negligent act by selling to a visually impaired man. In addition to that, the difference between the Walmart case and this case is that there are multiple degrees of separation between the manufacturers and the dealers. The manufacturers are not the dealers and they aren't directly handing to straw purchasers, nor are they committing any directly illegal act.
But is there anything manufacturers can do to make sure that their guns are not going into the hands of straw purchasers, since this is easily identifiable as a problem?
They are not legally held accountable or expected to do anything about the issue, nor do they have any connection or foreseeability towards the issue. The second main issue that breaks the proximate causal chain is multiple independent criminal acts breaking the proximate cause chain. As it was held by the Exxon case, typically intervening volitional criminal acts are superseding causes that eliminate the proximate causal chain. Mexico's complaint relies on at least 4 independent volitional criminal acts, being 1, the straw purchasers buying defendants' firearms in the United States illegally, 2, the illegal smuggling into Mexico, 3, the illegal sale in Mexico, and 4, the cartel's actual crimes, murder and mayhem in Mexico.
But Counselor, to my fellow member of the bench, you've already taken the position 1 step. A second step is a step too far.
Exactly. Another step is too far. And the fact that there are 4 crimes that happen in these later alleged steps shows that the proximate causal chain should be broken.
Well, in the industry itself, though, please correct me if I'm misunderstanding the industry, From the manufacturer, it goes to the licensed distributor. From the licensed distributor, it goes to the licensed retailer. From the licensed retailer, it goes down. So your position is that there's no responsibility held by the manufacturers past put it into the hands of the wholesaler, when it's the industry standard that the wholesaler is going to sell it to a real retailer. That's the industry standard, is it not?
What is the question?
You're limiting any possibility of liability on your manufacturer's part after step one.
Yes.
And in the United States, the license, and it's approved by law, step one is from the manufacturer to the licensed wholesaler.
Yes.
Wholesaler to retailer, licensed, approved by law.
Yes.
So we're already 2 steps away from the manufacturer. Then retailer down. So your position is, even though the industry procedures are wholesalers sell to retailers, right then and there, beyond that point, there can be no held responsibility. Is that your position?
Yes, they shouldn't be held responsible for anything that is done past that step, because none of it is within their control. And even if there were to be taken those steps past, if you were to say the chain is able to be longer than that, the chain is interrupted by the 4 crimes.
But Counselor, wouldn't you agree that, let's say for argument, leading up until when the case was originally brought forward in 2021, that Smith & Wesson had no knowledge. Now they do, and 4 years have passed, so they are knowingly contributing to this problem, continuing to sell. No effort has been made to change their business practices. Wouldn't you say that they are knowingly and knowingly contributing to this problem?
No.
Directly?
No, I would not say that they're directly doing anything.
Would you say that it's foreseeable that this is going to occur?
I would not
So
say
many
so.
of your guns show up?
I would say that it's unreasonable to ask the manufacturers to foresee any of the things that happen down the line, because those steps, including the wholesaler and the dealer, where the crime is first committed at the dealer, each step includes a license up until that point.
So
A
the
license-
fact that it keeps happening and guns keep being found, it's still not foreseeable that you might find another gun and it might keep happening?
For the sake of argument, I could say that it is foreseeable, but even if it was foreseeable, the manufacturer should still not be held liable, because the court has ruled multiple times in the past that foreseeability isn't enough to fulfill the predicate exemption of the PLCDA, and foreseeability, specifically foreseeability alone. It would need to be accompanied by something else, such as an affirmative action or contact with the cartels.
There's no allegation here that any of these sales to the wholesaler, the retailer, or the straw purchaser violate any regulation or law in the United States, correct?
No.
There's no allegations made by Mexico that there's anything illegal done in this chain of distribution. Is that accurate too?
No, they're claiming that there is an illegal purchase from the dealers. The dealers are doing something wrong by selling to these straw purchasers, and as well as the smuggling across the border is illegal. The sale in Mexico is illegal, and clearly the cartel's actions in Mexico of murder and mayhem are also illegal. However, none of this is the responsibility of the manufacturer. None of it is the intent, and none of it is something that they foresee or have control of in any way.
So if the gun manufacturers stop the processes that Mexico alleges causes cartel violence, do you think their cartel violence would be of lesser extent?
What would be some of those actions that the petitioners could stop?
Like if you knew a straw buyer was selling to cartel-affiliated people and they were still selling to the dealers who sold to the straw buyers, couldn't that be considered as foreseeable?
So the manufacturers sell to a wholesaler. I see that I'm out of time. I'll answer your question briefly. So the manufacturers sell to a wholesaler, and a wholesaler then sells to a dealer. If anybody in that small part of the chain could be held responsible, it should be the wholesaler that should be stopping selling to the dealer. However, to put the blame on anyone, we should put the blame on the cartels in Mexico. They're the ones directly committing these crimes. They're the ones killing people. And the manufacturers do not intend any of this to happen. They don't facilitate any of it. For the foregoing reasons, the petitioner respectfully requests the court to overturn the decision of the First Circuit Court of Appeals.
Thank you, Counselor.
Thank you.
respectfully request this court to affirm the decision of the United States Court of Appeals for the First Circuit. This is a case about holding gun manufacturers accountable for their direct contributions to cartel violence in Mexico. As my co-counsel Ms. Crouch has already argued, all Mexico is asking from this court is a chance to prove its claims to a jury. While Ms. Crouch proved that Mexico's allegation shows that gun makers are guilty of aiding and abetting, I will show this court that the petitioner's actions are, in fact, the proximate cause of Mexico's damages. This court should affirm the First Circuit's decision on this issue for two key reasons. First, Mexico's injuries are a direct result of the dealer's unlawful firearm sales and are a foreseeable consequence of the gun maker's bad acts. Second, the petitioner's arguments to the contrary fail to break the clear causal chain between the petitioner's criminal acts and the harm Mexico suffered. Proximate cause requires direct correlation between the alleged criminal conduct and the harm received. This analysis is required so that liability is not extended to cases where there is a lack of causation or if the cause is remote and speculative. Mexico's injuries are directly tied to the unlawful firearm sales facilitated by the petitioners. As the court noted, Mexico's damages, such as the increased cost of law enforcement, economic losses, and the strain on public health, stem directly from the flow of illegal weapons into the hands of traffickers. The gun manufacturers knowingly supplied firearms to dealers who traffic them in cartels, directly linking their actions to the harm that Mexico suffered.
Counselor, if I might interrupt, you used the term facilitate, and how are you defining that in this scenario?
So we are saying they're facilitating the guns getting to the cartel because they know exactly which dealers are the rogue dealers that sell the most guns to the cartel, and their guns have also been traced back to them from the ATF, so they know that their guns are ending in the cartel, up in the cartel's hands, and they have done nothing to stop their guns or monitor their practice more, stop their guns from going.
And in this case, have any of those dealers been named?
So these dealers have been named. A Washington Post article actually outlined the 12 dealers which sold the most guns to the cartel. And these petitioners did not stop selling to these dealers, even though they were named specifically by the Washington Post.
Are they selling to the dealers or are they selling to the wholesalers? Smith & Wesson selling to the wholesalers who sold to the dealers?
They're selling to the wholesalers who sell to the dealers, but they can foresee that these guns will end up in the cartel's hands because they know exactly which rogue dealers these guns are going to.
Are you saying that foreseeability is sufficient to establish a causation chain?
In this case, foreseeability is enough to establish a causation chain because foreseeability here is so evident that the guns end up in Mexico's hands. And there actually have been cases where foreseeability is enough to establish a causal chain if the intervening criminal conduct is also foreseeable. For example,
you've spoken of the intervening criminal conduct in the passive voice. You said the horror that Mexico suffered. Did they suffer it with no responsibility on their own, or are they part of the causal chain as well?
So Mexico is not part of the causal chain. These guns are coming directly from manufacturers, and they are harming the Mexican government. And going back to how foreseeability is enough in this case, another case involving Avis Rent-A-Car. Avis left the car unlocked, running, and unattended in a high-crime area. A thief stole this car and later injured the plaintiff. The Florida Supreme Court held Avis liable because the theft and resulting harm were foreseeable consequences of its negligence. Similarly, in this case, gun manufacturers knowingly supplied firearms to dealers who trafficked them to cartels, and that created a foreseeable risk of harm, just as Avis's negligence foreseeably led to theft and injury. Third-party act did not break the causal chain in that case, and it does not so here. Petitioners also raised 4 other arguments related to attenuation, intervening criminal conducts, derivative injuries, and apportionment. Each of these arguments should fail. Petitioners argued that the causal chain is too attenuated, claiming that the court went beyond the first step in linking firearms dealers' sales to cartel violence. However, they misinterpret where the causal chain begins. They claim it starts with the broad business activities of the firearm manufacturers, when in reality, the first step occurs when the manufacturers knowingly provide weapons to dealers, when those dealers illegally sell these same weapons to the cartel. Here, the violation is the dealer's criminal firearm sales that the petitioners unlawfully gave an event. In the predicate
Counselor, if I can interrupt. So is your position then that in the United States, manufacturers need to be policing each and every wholesaler who sells into a retailer who then sells? So is your position they can keep manufacturing, but they have to independently police how many links down the chain?
So we are asking them to monitor the sales of the rogue dealers that directly sell to the cartel, because these dealers have been specifically named for them. But only 15% of dealers actually sell illegal guns. The overwhelming majority, over 85% of dealers sell no illegal guns. However, they are not stopping selling or even monitoring the line between the dealers who do not, or who sell the guns to the cartel. And they're not doing anything to stop them from selling or monitoring them. And even though they know exactly which dealers they are.
You said there's only 12 rogue dealers right now, right?
Those were the 12 that were outlined in the Washington Post article.
Okay, so if those 12 start to be monitored, what's going to happen when 12 more pop up and then another 12? Do you think there's enough time and resources able to be invested into monitoring however many?
So for that reason, that is exactly why we are suing the manufacturers on this case. Because if we are able to go to the source of where the guns are being manufactured and tell them to monitor these sales and tell them to stop stop marketing to the cartel, they also put Mexican flags on these guns, and they call these guns the Super El Jefe or the El Grito. And they know that these guns end up in the cartel's hands in large numbers. They are sold in bulk to the cartel.
Excuse me, are those modifications you're talking about directly made by the manufacturers in order to specifically advertise to the cartels, or is there some other motive behind those designs?
So, as far as the complaint says, these guns are marketed by the dealers with these names, and marketing by the dealers with these names, as they are also putting the Mexican flags on the guns.
Is that illegal?
It is not illegal. However, they know that these guns are ending up in the cartel's hands, and that they should be monitoring the sales more to the dealers that they know sell most of these guns in bulk to the cartel.
Counsel, is your position that putting the flag of the country and the name in their language puts a manufacturer on notice that is then going to get into the hands of criminals and used for mayhem and killing?
So what put them on
sort of a flag of another country?
So what put them on notice is that these specific guns go to the cartel in high numbers. Not just that they are putting them on the gun. They know that these guns go to the cartels in bulk. These guns are coveted by the cartels. And because they know that they're coveted by the cartels and they are recovered at the crime scenes of cartel violence, they should be monitoring the sales of these guns to these rogue dealers more closely.
And they're also purchased by law-abiding citizens, are they not?
These guns are purchased by law-abiding citizens,
yes,
as they are also purchased in bulk by the cartel through illegal methods, and that is where we are trying to monitor.
You said large numbers, and following up on Justice's question, can you delineate or indicate what numbers we're talking about here with respect to cartels and non-cartel members purchasing these types of weapons?
So, over 300,000 guns from American manufacturers end up in cartels' hands, and 70% of the guns found in crime scenes at cartels.
I'm speaking specifically about the guns that you talked about, the flag, or the El Jefe, or the...
I do not have the specific numbers on these guns. The complaint outlines that they are being distributed in bulk to these dealers, knowing that these guns end up an overwhelming number in the cartel's hands. The intervening...
Excuse me, so I asked this question to the other side, but I just wanted to hear your thoughts on if the gun manufacturers stop the processes Mexico alleges causes cartel violence, do you think this violence would be of lesser extent?
I think this violence would 100% be of lesser extent. If they were able to monitor these sales more closely, then they would be able to stop the majority of these guns ending up in the cartel's hands, as they know exactly which one of these rogue dealers are, and they know that these guns go to the rogue dealers and they are sold to the cartel from them in bulk. And if they are able to monitor the sales more closely, then it would stop these guns from getting into the cartel's hands in that high number. Petitioners also argue that the trafficker's actions break the causal chain, but a defendant remains liable when the harm is a foreseeable result of their conduct. The defendant's actions create or increase risk of criminal misuse, that misconduct is not an independent act, it is a predictable consequence. Criminal acts do not automatically break the causal chain. I see that I'm out of time. For the foregoing reasons, respondent respectfully requests this court to affirm the decision of the United States Court of Appeals for the First Circuit.
Thank you, Jennifer. Marlon?
Madam Chief Justice, may it please the court. My name is Bella Moreland, and I am representing the amicus Mexicans Against Gun Violence in support of the Mexican government. Respondent respectfully requests this court to affirm the decision of the United States Court of Appeals for the First Circuit. The illicit trafficking of firearms in Mexico has had a disastrous impact on the country, particularly on public security and human rights. The unregulated flow of United States firearms into Mexico fuels the violence generated by criminal organizations, such as drug cartels, that destabilizes entire communities. This blood-soaked landscape has taken the lives of tens of thousands of Mexican civilians and displaced untold more, causing a staggering humanitarian crisis. This crisis is being driven by the reckless business practices of the U.S. gun industry, including supplying firearms to known straw purchasers without taking reasonable steps to prevent illegal sales. First, the effect the cartels and their American guns have had on Mexico has been devastating. Ms. Sarah San Martin Romero, an educator and peace activist for a civil society organization in Mexico City called the Center of Ecumenical Studies, cites the following statistics that show the devastating effect firearms have had on Mexican civilians. Between January 2015 and October 2024, 6,936 homicides of children and adolescents between birth and the age of 17 were committed with firearms. In 2023, 31.4% of all homicides of children under the age of 10 were committed with a firearm. Many children have lost a parent or have been orphaned due to gun violence. Victor Vivas and his then 12-year-old sister lost their mother, Maria Vivas, when she and her friend Rosie were attacked and shot to death. Victor was forced to identify his mother's body. Rosie's 3-year-old daughter witnessed the attack that killed her mother. From 2007 to 2023, murders of women with firearms increased by 371%. Dr. Fabian Mendez, a researcher on global conflict and cooperation, points to the following frightening statistics about the displacement of Mexican citizens due to gun violence. At the end of 2023, approximately 392 Mexican people were estimated to be displaced as a result of violence, a figure that has consistently increased over the past 10 years. The Jalisco New Generation and Sinaloa cartel criminal organizations were responsible for 4,000 displacements in a town along Mexico's border with Guatemala, evidencing the southward spread of these cartels. Second, it is logically impossible that Mexican cartels are getting the guns from inside of Mexico. Mexico is renowned for having some of the strictest gun laws in the entire world. There is only one gun store in the entire country, and it is heavily guarded by military officers. The Ministries of Internal Affairs and National Defense has severe restrictions on what guns people can buy and who can buy those guns. The Mexican government reports that the store only sells 38 guns a day to civilians. In 2013, only 3,140 citizens were able to obtain a gun license. Third, the strengthening of the cartels by the American gun industry has not only had a devastating effect on Mexico, but also on America. Specifically, the Mexican cartels are largely responsible for the fentanyl crisis in the U.S. American guns, easily available because of illegal sales in America, have enabled Mexican cartels to stay in power. Firearms smuggled from the United States to Mexico allow cartels to battle Mexican security personnel and protect their narcotics trade. The firepower advantage has rendered it difficult for Mexican law enforcement to dissolve cartel operations, allowing the organizations to establish and solidify fentanyl smuggling networks. The U.S. opioid crisis is worsening as a result. The failure to enforce gun smuggling across borders has allowed the cartels to control the production and trading of fentanyl. Congressional testimonies describe how cartels smuggle guns with U.S. origin into Mexico that they then use to guard drug houses, buy rude disputes in smuggling, and intimidate the police. This creates a self-perpetuating cycle. The more guns cartels can buy, the safer they are and less vulnerable they are to being dismantled, allowing them to produce more fentanyl and more trafficking hubs. The rising rate of fentanyl overdose fatalities in the U.S. is the product of this process. The unwillingness of the U.S. gun industry to crack down on illegal sales has allowed the cartels to solidify their grip on fentanyl manufacturing and consequently fuel the existing public health epidemic. For the foregoing reasons, the respondent respectfully requests this court to affirm the decision of the First Circuit.
Thank you, Counselor. So, counselors, thank you so much for your advocacy, your level of preparation, dedication, and delivery were very impressive. So for those fielding questions and those with prepared remarks, delivering your brief. And it's been a pleasure to be part of your advocacy and wish you the best. And thank you for all who gathered here to watch what is a lot of hard work on display. So thank you all very much, and we are going to retire to deliberate. Thank you.
On behalf of all of the students and faculty who have made this event possible, we thank you for coming out tonight. Please help me